Sovsits are fun. They think they're going to have intellectual debates with me in the comment sections. They think they're smart. They think they have winning arguments. First one up, first one to bat is Gypsy Heart. I'm going to beat you two ways on this, Gypsy Heart. So I hope you're taking notes. He says you're being honest. Haha, I doubt it. 650, you say personal jurisdiction comes when the court gets the indictment against you.
Subject matter jurisdiction. Personal jurisdiction happens when the court gets the indictment against you.
So I'm obviously talking about criminal. WTF, how does a piece of paper with writing on it obligate one to consent to personam jurisdiction? It doesn't. Men with guns obligate you to show up or to be present. They're the ones who force you to go to court if you choose not to do so voluntarily. It's not the piece of paper doing it, it's the men with guns. Stay awake. He says, I don't know what it is with the excessive punctuation and strange capitals. Capital personal, capital jurisdiction. I don't know. It's like a sovereign citizen thing. They believe in word magic or something. I don't get it. He says indictment, noun, a formal document written for a prosecuting attorney charging a person with some offense. Okay, that's a very basic definition of a legal indictment. Yeah, you take it in front of a grand jury. The grand jury prepares the indictment for the prosecuting attorney. Then it goes on without, he has all this punctuation up here, and then there's no punctuation right here where you'd think there'd be a period. I don't get it. Indictment, noun, an accusation of wrongdoing. Okay, so one is a legal definition of it, or a more legal. The other one is a more vulgar definition of it, a more common usage definition of it. Liars will be liars. The wordplay, amazing. Then he says, from Cornell Voodoo Law School, again, amazing wordplay. Obtaining personal jurisdiction, typically for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state in which the court sits, and the defendant needs to voluntarily appear in court. Again, he could have literally just copied it and pasted it. I don't get it. All right, so let's look at this. This is another. It's basically a dictionary entry. Wex is I think a legal encyclopedia that Cornell uses. Notice all the tags: legal process, civil procedure, Wex definitions, jurisdiction, civil procedure, federal rules of civil procedure, service of process, which is a civil procedure thing, and subject matter jurisdiction. So we're probably talking about civil procedure. But look, it does say the defendant needs to voluntarily appear in court. Oh, there's a link. Let's follow the link. It says general appearance. The first time an attorney appears in court on behalf of a client after making a general appearance, the attorney is then responsible for all future appearances in court unless relieved by a court order or substitution of another attorney. Notice that this is not talking about personal jurisdiction. So something went wrong and screwy. I don't know exactly what, but this doesn't mean what you think it means. Let's continue on. Federal Rules of Civil Procedure 4K describes whether states courts would have the authority to adjudicate the claim as it relates to personal jurisdiction. This is 4K. Territorial limits of effective service. In general, serving a summons or filing a waiver of service establishes personal jurisdiction over a defendant who is subject to the jurisdiction of a court of general jurisdiction in the state where the district court is located, who is a party joined under Rule 14 or 19 and is served within a judicial district of the United States and not more than 100 miles of where the summons was issued, or when authorized by a federal statute. So this is giving a general overview of when a federal civil complaint, when a summons would be give personal jurisdiction. It's not talking about criminal, but also notice it doesn't say that the defendant has to consent. In fact, on the summons, you have to notify the defendant that a failure to appear and defend will result in a default judgment against the defendant for the relief demanded in the complaint. So if you don't appear, you get a default judgment and you lose. Now, there are ways you can fight that, but generally speaking. And I have personally filed 2 writs. I haven't been a lawyer for very long, but I've filed 2 writs of execution on summary judgments that were from defaults by the defendants for not appearing. So it does. Those are in state court, in California state court, but it's. I don't know I don't know what they were trying to do with that. Defendant needs to voluntarily appear. Obviously, the link has nothing to do with it, so I think they're just wrong. And the link that they cite to says nothing about the defendant needing to voluntarily appear. It just says that that generally. What was it again? In general, serving a summons or filing a waiver of service establish personal jurisdiction over a defendant, and nothing in there following that says if they show up. And obviously links will be in the description. So that's wrong, and you're relying on dictionaries and encyclopedias. The law is much more complex than that, Gypsy Heart. I do hate to break your heart, but you can't just have a smooth as ice intro and a few bullet points to win any legal arguments, especially not with a lawyer. Then he says, so if James, okay, so we're talking about Freeman, innocent and unwilling. I don't know if he's innocent. He's probably unwilling, but that doesn't matter. You don't know if he's innocent. I don't know if he's innocent. Only James knows if he's innocent. And I'm not prepared to take anybody at their word. He does have a reason to lie. So all I can say is I don't know if he's guilty or innocent, but that doesn't matter. Then he says under threat of violence. He's not under threat of violence. There are consequences for him not showing up, but it's not a threat of violence. Just saying that it's a threat of violence. It's a threat of arrest, but it's not a threat of violence. So if James does appear, it is not voluntary, doesn't matter. And he is not giving the court personal jurisdiction. He doesn't have to give the court personal jurisdiction. Personal jurisdiction is not his to give. The court has it because the indictment said that there was probable cause that it was him who committed the crime. But instead asking the prostitutor, so witty, to prove factual evidence that their codes and laws apply to him. He wants the prosecutor to prove to James wants the prosecutor to prove to James that their codes and laws apply to him. James doesn't have that right. The prosecutor has to prove personal jurisdiction and territorial jurisdiction to the jury. The court is who is supposed to determine subject matter jurisdiction. James, nobody has to prove a damn thing to James. Literally, no one has to prove anything to James. I don't even know why you would think that they have to prove anything to James. There's this self-entitled kind of thought process that sovereign citizens have. You need to explain to me why you're doing this. No, they don't. You need to prove to me this. No, they don't. A perfectly rational clarification and the burden of proof is on the prostitutor to establish every element, including jurisdiction. Yes, he has to establish every element. And as I said, personal jurisdiction is established, and it's proved beyond a reasonable doubt once the jury finds that James did it. They lose it all if the jury finds James didn't do it. That's personal. And then territorial, the prosecution has to prove that the crime was committed in whole or in part in Texas. They have probable cause that it did happen in whole or in part in Texas. And once the jury determines that it did or didn't happen, then either they have or they don't have territorial jurisdiction. It's up to the jury to determine. And then the other one of note is this Lysander. Lysander Spooner. Oh, Lysander Spooner. Go read Lysander Spooner. I don't know why. Lysander Spooner was a nobody. This is Lysander Spooner from Wikipedia. He had a disappointing legal career and a failed career in real estate speculation. He had a failed American letter mail company. He wrote essays. No one cares. This is the essay they wanted me to read. They think it's going to change my mind and have me suddenly discount all of the Supreme Court rulings that I've read, the appeals courts rulings I've read, the state Supreme Court and state appellate court rulings that I've read. Just throw all those out. Those don't matter because Lysander Spooner wrote an essay. Well, okay. Let's see how smart Lysander Spooner is. The Constitution says, and then he reads the preamble: "We, the people of the United States, in order to form a more perfect union." Blah blah blah. This is the little preamble to the Constitution. In fact, we can look it up. Preamble to the Constitution. There it is. Preamble. It's the preamble. Oh, hey, look. What's the main purpose of the preamble is a good question that we might ask ourselves. The preamble is the opening statement. It explains the reasons why the framers made our government a republic. By doing this, the founding fathers replaced the Articles of Confederation. Ah. Ooh. It's not law. It's the preamble. It's not law. All right. So the meaning of this is simple. Or the meaning of this is simply: we, the people of the United States, acting freely and voluntarily as individuals, consent and agree we will cooperate with each other in sustaining such a government as provided for in the Constitution. Okay. No, but okay. Because it's we, the people of the United States. We're not the United People. We're the United States. In order to form a more perfect union of states. We're union of states. It's the United States. The states are united. The states are in a union. Christ, this is dumb. The necessity for consent of the people is implied in this declaration, only if you're retarded. The whole authority of the Constitution rests upon it. No, it doesn't. If they did not consent, it was of no validity. That's not true. Of course it had no validity, except as between those who actually consented. This is Article 7 of the United States Constitution. It says the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. There's no mention in here of the people. The smallest state with the least people in the Union has exactly as much authority or as much power to change the Constitution as the largest state in the Union. It's just how many states agree to it. I think it's 3/4, if I remember correctly. If 3/4 of the states agree to it, bada boom, bada bing, new amendment changing the Constitution. Presumably, they could amend the whole Constitution out of existence if they really wanted to. It is of no validity except as between those who actually consented. Those that actually consented are the states. And the states are still in existence. New states are admitted to the Union. New states consent to the Constitution. That's why this is so stupid. These people think that the Constitution is a contract between the people. Well, I didn't sign this Constitution. I didn't agree to it. The state did. Well, I didn't agree to the state's Constitution. Well, that's just too bad. Move to a different state. Men with guns, remember them? They will still enforce it. Anyway, the U.S. Constitution, as determined by the Supreme Court, is the law of the land. It means exactly what the Supreme Court thinks it means. Nothing more, nothing less, nothing different. And the reason why is because the Supreme Court is authorized by the Constitution to determine the meaning of the laws, including the Constitution. So I hope you've enjoyed this little delve into stupid people on the internet. Thanks for watching. Have a great night.